by Heffernan Consulting. Excuse me. We're so happy you can join us today. My name is Steve Thompson, and I'll be your moderator. And I'll be working with Diane Probert and your presenter, Anne-Marie Toll-Mason, on monitoring questions you may have during the session. And before we open up the session, let's review just a couple of key items. All of the webinar materials that we discussed today, and that's all of the items that Anne-Marie will present, they can be found at this particular site, which is aspenrmg.com/Heffernan webinars. As a matter of fact, all past webinar information is also on here. And if you go to scroll down to the bottom of the page, you can see that the webinar materials are listed here on this particular page. So a follow-up email will be sent to all of you who are in attendance today with this link and the information for that. So by the end of tomorrow, or I should say by the end of today, the information for today's session, including the presentation itself, will be uploaded to the site. So we're great to have you, and that's the one part of sort of some housekeeping. Number two, if you have trouble with your internet connection during the webinar, we recommend leaving the presentation and logging back in. Most times it's just an issue of connection. Also, if you have any audio difficulties or a telephone line goes dead during the call, just hang up and call back in again to the same number. If for some reason all the lines go dead, just watch for the on-screen chat box for an alternative call-in number. Feel free to ask questions or provide feedback via the chat box during the webinar. If you're using a tablet, you may need to tap on the screen for the options bar to appear, and then you can select the appropriate option. We may not respond immediately, but we'll work your questions or your feedback into the presentation as we go through. And if we can't get to your comment or question during the session, we'll be online afterwards to respond. You can always email us at moderator@aspenrmg.com for up to 24 hours after the webinar. This will be a 1-hour presentation. Questions and comments are very much encouraged throughout. And lastly, as you can see, we have a number of webinars upcoming. And again, those are all listed on the same site. And we encourage and welcome you to join. And then we also have a listing of the link is here, to an online preventing sexual harassment. And we have a number of those coming up, 2 more in English for the year on June and September, and then in Spanish in October. So that's an overview of where we're at. With that, let's begin today's webinar, Successful Separations. And I'm going to go ahead and turn over this presentation to our presenter today, Anne-Marie Toll-Mason. So Anne-Marie, I'm going to make you the presenter. And today's interactive session will be facilitated by Anne-Marie. She is also the president of HR Source Consulting, and she is a managing consultant with Aspen Risk Management Group. She's an HR professional with 20 years of practical management and corporate training experience, and her experience is listed on screen. She is an instructor and facilitator for various HR management topics, including preventing sexual harassment, and she works with has worked with hundreds of companies. I'd say by now, Anne-Marie, it's probably thousands. She holds the designation as Senior Professional in Human Resources. That's the SPHR. She's the former president of SHRM, a San Diego chapter, and she's been an expert witness for legal proceedings relating to harassment and discrimination, and she's an investigator for harassment and discrimination complaints. Anne-Marie, with that introduction, I welcome you and I welcome our audience, and I turn it over to you.
Well, wonderful. Thank you so much, Steve, for that introduction, and it's great to be with all of you. I really appreciate your taking the time to spend with us this morning. And I wanted to just reiterate something that Steve said, and that's that we really encourage your comments and your feedback. I think that most of us have been through, unfortunately, having the experience of requiring us to terminate an employee, and through those experiences we come up with some best practices, some ideas that I really think it would be helpful to share with everyone else. So if there's something that comes up during the webinar that you think would be of value to share, go ahead and type that in your chat box, and we'll be happy to discuss it and share it with everyone. Also, throughout our webinar, we're going to be asking you some questions that will appear on your screen, and we will allow you an opportunity to answer the question and kind of take a poll as to what the majority of the audience thinks. So we're going to add a little bit of that throughout the webinar as well. So it should be a good time today, and I'm looking forward to learning from all of you. We, of course, have to have a disclaimer. I am an HR professional with significant experience. However, every situation is different and really needs to be considered as a separate situation, especially terminations, which can become very litigious. So I always encourage someone to seek out professional assistance, and oftentimes that would be an employment law attorney. And I, myself, as an HR professional, reach out to employment law attorneys all the time when I expect or anticipate that the situation might become litigious. That you just want to make sure that you're getting in front of it and being proactive instead of being reactive after the termination has occurred and problems arise. We have a number of objectives today, and these are some of the things that I hope to accomplish. And I also hope to accomplish answering any questions that you might have. And again, I won't be providing specific advice, and always please consult with an employment law attorney. But hopefully, when all is said and done, we'll be able to understand the different types of employment relationships and understand some of the laws that come into play, what are some good reasons for terminating employees, and ways in which we can prevent or eliminate or at least reduce our risk of wrongful discharge and discrimination lawsuits. So with that, we have our very first polling question, and I'm going to ask Steve to assist me in this regard. So Steve, would you share that first question with our audience, please?
Absolutely, Anne-Marie, and just give me a moment to launch that question. And that question is now launched. And for those of you that have first time with a polling question, you simply will read the question to yourself, and then right on the screen you'll either answer true or false. And in this case, it's if you have an employment at will relationship with an employee, you have an absolute right to fire that employee at any time for any reason. And we usually take about 30 to 60 seconds for all of you to take a moment to vote. And we have a great audience today, Anne-Marie. As a matter of fact, we have just about 70% of everyone already voting, and that's within about 30 seconds. So we'll give everyone just a few more seconds to wrap up their votes. Again, either true or false. It's not both, either one. And for those of you that the first time on a webinar, we have our process is to be integrated and engagement. So Anne-Marie, we have a 95% of our audience has voted. I'm going to go ahead and close that poll, and then I'm going to share it with the audience. And Anne-Marie, 63% felt the answer was false. 37% felt the answer was true.
All right. Well, the answer here is false. So the majority of our audience got this one correct. But it is extremely confusing. If you have an employment at-will relationship with an employee, you don't have an absolute right, because state and federal laws, as well as court ruling, impose limitations on the employment at-will doctrine. So you generally need a justifiable reason for termination, even in an at-will employment relationship. And here in California, we do have that at-will relationship with our employees, and most of us will see those statements throughout our employee handbook. They're often in our offer letters and so forth. And it's really important to have those disclaimers in our handbook so that we can maintain that employment at will relationship with our employees. And with that said, you want to make sure that you have followed all of the laws. So here it says common law doctrine stating that the employers have the right to hire, fire, demote, or promote whomever they choose. The key part here is the last part of this sentence, unless there is a law or contract to the contrary. So you want to make sure that you're reviewing all of that to see whether or not your termination may come under question and may lead to a potential claim. Other types of employment relationships include employment contracts. So sometimes we enter into contracts with our employees which negate that employment at will relationship and outline a new relationship. So if you have an employment contract with someone, you'll want to carefully review it to see what the terms and conditions are for which you're allowed to terminate an employee. And then sometimes it'll stipulate specific reasons for termination that would require you maybe to pay severance or offer a notice or something along those lines. Most of the employees probably don't have employment contracts. Where I see those coming into place are generally the very senior level executive teams. Those employees often will have these employment contracts and will not be employment at will employees. Then there's also that psychological contract, which is that unwritten expectation that all employees have with their employers about the nature of their work relationships. And Steve, we have another polling question.
Yes, we do, Anne-Marie. I'm going to go ahead and launch that for our audience. And in this particular question, we're going to launch it. And again, for each of you that are joining us, this is either a true or false. 2 federal laws that impose limits on termination are the Civil Rights Act and the Fair Labor Standards Act. True or false? Two federal laws that impose limits on termination are the Civil Rights Act and the Fair Labor Standards Act. And Anne-Marie, we have a very, very fast-acting audience here, where we have pretty much everyone has voted. And for those of you just taking that last few seconds to get your vote in, it's now time to do it. Okay, I want to thank everyone for your votes. We'll close the poll. We'll share it with the audience. And Anne-Marie, your audience has answered 78% true, 22% false.
Excellent. Well, you see here that the first 2 are actually the Civil Rights Act and the Fair Labor Standards Act. So the answer here is true. And there are also a number of other federal laws that come into play, and it can be very confusing. I am always trying to stay up on the latest laws, and these are the federal laws, but there's also laws in each state. So for those of you in California, you have the Department of Fair Employment and Housing, which is the agency that oversees the Fair Employment and Housing Act. So you want to become familiar with the regulations associated with the Fair Employment and Housing Act. And you can get that information from the Department of Fair Employment and Housing website. So there are a number of state laws that come into effect depending on what state you're in. And so you want to make sure you're somewhat familiar with these. But again, managers and supervisors are not expected to be attorneys. I always suggest that managers and supervisors consult with their HR professional, and the HR professional will usually know when to raise the flag and call the employment law attorneys in for help. Another polling question, Steve?
You're absolutely right, Anne-Marie, and let me go ahead and launch that question for our audience. And so the question is, before terminating an employee for poor performance, try other possibilities such as, and please select one of these if you would. Before terminating an employee for poor performance, try other possibilities such as, and I think you know where this is going, Anne-Marie.
I think I do.
I think so. And the audience has chosen overwhelmingly 92% as all of the above.
Absolutely. It's really important to try to work with an employee to correct performance issues before terminating them. There's a number of reasons to do that. First of all, you may have spent a lot of time and effort in finding the person, bringing them on, getting them trained, and poor performance may be just something that is easily fixed. Sometimes it's just training, some additional training. Sometimes you need to take the person aside and have a chat with them, which would be a verbal counseling. And written warnings, unfortunately, are necessary at times when all of the other, all of the other attempts to correct performance aren't successful. Sometimes people need to understand how serious it is and understand specifically what the consequences are, which usually include termination of employment. And if all that doesn't work, then of course terminating the employee is the right thing to do. Now you'll hear me say again and again throughout our webinar today that you really need to document, document, document. And the reason I say that is you want to reduce your risk, limit your liability for those employment claims that come about after terminations. So in order to best situate yourself in the event that you do get a claim, this documentation is extremely important because that's the first thing they're going to ask for, is they're going to ask for you to send all of that documentation to them. And employees who are anticipating that they'll get fired are probably keeping their own documentation, so you'll want to make sure that you are doing the same thing as well. Now let's talk a little bit about insubordination. This is a very common reason that employees are fired. And insubordination is a good reason to let someone go. But you must be able to prove that the employee fully understood what was expected of them. Now, how can you do that? Well, what I, as an HR person, suggest is that job description. And many organizations do have them, but they're somewhere filed in the HR office and they're not utilized as they should be. My recommendation is when you have a new employee to have the manager sit down with that employee during their first week of work and go over the job description with that employee. Have the discussion about all of the duties and responsibilities and expectations, and then have the employee sign their job description and explain to the employee at that time that, hey, this is what we expect of you. These are the this is the bare minimum of what we expect. Things are going to change from time to time because it's the way business goes, but we at least expect you to do these things, and that we're going to hold you accountable for these things throughout your employment, and we're going to regularly give you performance evaluations, and we're going to consider these things, among others, during that performance evaluation discussion. So also, not only do you need to communicate what your expectations are through your job description, through regular performance discussions, you want to make sure that your expectations aren't illegal. So if you have someone in accounting, for instance, you need to follow the general accounting principles. You certainly couldn't ask someone to categorize certain expenses where they don't belong and things like that. So You can't ask someone to do something that's illegal, and certainly you wouldn't be able to fire them legally for insubordination related to asking them to do something that wasn't legal. Also, the expectation really does have to be an important expectation. It shouldn't be something that's too trivial if you're going to terminate for that reason. And it has to be understood that the employee was required to comply and that the insubordination was intentional. So that's often the most difficult one, is to prove that the insubordination was intentional. So it really depends on the circumstances. It depends on what was said, who was around, whether or not the person had been warned in the past that that kind of behavior was not acceptable, and so forth. Additionally, I would suggest please just focus on the most serious offenses if you're going to terminate, and consider all alternatives before making that decision. And make sure, again, document, document, document.
Anne-Marie?
Yes, Steve?
We do have a question, and
yeah.
I'm so happy that you had that brief pause in between slides, because we have a question from one of our participants, and it relates back to the issue of verbal, and I'll ask the question. Is a verbal conversation which is documented by the employer but not signed by the employee a credible documentation?
Well, yes, it is. It's more credible if it's acknowledged by the employee that the discussion took place. And one of the things that I really am in favor of is an email exchange following a verbal counseling. So what that might look like is an email that would read, thank you so much, Steve, for our meeting with me today. We talked about your attendance issue and that you called in sick, that you failed to call in sick as you were supposed to, and I reviewed our company policy with you, which is to call in as soon as you know that you're not going to be able to be in. And the reason is because it has an adverse effect on our business and your coworkers. And we were in agreement that you were going to follow the policy in the future. Thank you so much for meeting with me. And then, that I think that that's a great way in which to document that the conversation took place. You have that email exchange. Also, it's a great idea to do that follow-up verbal notation to go into the employee file. So you can print out that email and put it in the employee file as well. It's a great idea, too, if you can ask the person to, please reply that you received this email is another way in which you can do that. Really, it depends. You can take the tone to be as disciplinary or as, softer in nature, so you kind of can choose the tone of that email as well. So I like an email follow-up very much, since most employees do have email now. I always get asked the question, what if an employee fails or refuses to sign any kind of documentation? And that's not unusual, where employees feel like they don't want to sign it because they don't agree with it. But that doesn't mean that the conversation didn't take place. So it's a good idea when you have a disciplinary conversation with someone to try to have a witness, preferably someone from the HR department or maybe your manager, to be present. And that way, when or if a person should say, I don't want to sign that, I can say, okay, well, that's your right. You don't have to sign it. However, it doesn't mean that this conversation didn't take place. It doesn't mean that you don't have to comply with this. That still all has to happen, and we're going to still put this in your employee file. And if you'd like to put something in your employee file that explains your position on this matter, you're encouraged to do that, but this is going to go into your employee file. and then have that other person who is sitting in with you to sign as a witness. So I would say that the supervisor who had the discussion should sign it and say, this person, put their name down, put the time down, you have the discussion and the date. Say this person is refusing to sign this document and has been advised that they can put a note in their file explaining their own position on the matter, and have the other person sign as a witness that that conversation took place. And I think that that would be plenty to prove that conversation it did indeed take place, because that's really the reason you want the signature, is to later be able to prove that the person was indeed present and that that conversation was legitimate, that it did happen. So there's other ways to go about doing that. It's an excellent question.
Agree, Anne-Marie, and great response, too. Thank you, and we'll turn it back over to you. Thank you.
All right, so let's talk about attendance and tardiness, because this is another good reason for terminating employees, again, a very common one. But you want to make sure, again, that these employees do understand what the procedures are. Make sure that that it's clearly stated in your employee handbook. And you want to distinguish between what's considered excused and what's unexcused, and be able to interpret and apply the rules reasonably and fairly. And finally, document. Document, document. But you want to make sure that you're documenting everyone fairly. So you can't let some people come in late and then write up another person for being late when you're not doing that for others. I know that there are some positions, such as the person who answers your phone, the person who has to unlock the door for the customer, whatever the case might be. There are some positions really where timing is of the utmost importance and has a significant effect on your operations, and others where, well, if I'm in HR and I get in 20 minutes late, it's not going to be as big of a deal necessarily as if I was the receptionist getting in 20 minutes late. However, you still want to hold people accountable and not show favoritism, because that can lead to charges of discrimination and unfair treatment. So you really want to be as consistent as possible in holding people accountable for general policies. And Steve, can you help us out with another polling question?
I certainly will, and just so you know, Anne-Marie, we'll have a number of questions as we close out the session, because we've got a lot of good feedback from our audience. So let me go ahead and get this polling question launched. And this is: provided the company can prove the employee had excessive absences and tardiness, the employee has no legal recourse against the company. True or false? Provided the company can prove the employee had excessive absences and tardiness, the employee has no legal recourse against the company. And Anne-Marie, it's taking our audience less and less time to respond to these questions. So I'm going to go ahead and share the results. 76% felt that that is false. 24% felt it was true.
Okay. Well, this particular one is a difficult one. I agree with the audience that it would be mostly a false statement. Again, there's always a word or two that I really want to focus in on. And in this particular question, I want to say that you really want to be able to prove that the employee had excessive absences and tardiness. But also, you have to consider maybe the FMLA has come into effect, or the Americans with Disabilities Act has come into place. So you want to make sure the person isn't absent as it relates to some kind of a disability or some kind of thing that's protected under the Family and Medical Leave Act. So you want to listen carefully to the reason that the employee is telling you that they're absent, and you want to explore whether or not there might possibly be a violation of one of these laws before you terminate. So being able to prove that there were excessive absences, and also consider the reason for the absences, all right, and then terminate. So please do both before making your decision to terminate. And it is okay in a lot of situations to go ahead and terminate someone, but I have seen this come into play, specifically the ADA, where a person had been absent for a long time, frequently late, and it had to do with a serious medical condition that that person had been recently diagnosed for, and was going to a lot of treatments and doctor's appointments for that particular illness. So, again, do consider all of these laws before deciding to terminate for tardiness in attendance. And then there are other violations of company policy that could result in termination. It could be a serious violation of a dress code. Usually those are related to safety reasons. Also, the standards of conduct, most of us have those lists in our employee handbook, and they're called standards of conduct. They're things that say that you can't bring firearms to work, you can't gamble, you can't sleep on the job, things like that, which really you would think are common sense, but they are listed in most employee handbooks. So review your standards of conduct, because certain violations can actually result in immediate termination. Also, social media comes into play more and more these days, where a person may do a posting on a social media site, perhaps that is a violation of confidentiality. It may be very slanderous, perhaps. So these are things that you want to consider as potential reasons for letting an employee go. Computer use. All of us have stipulations in our handbook or otherwise written in the policy somewhere that says, hey, these are the reasons you can use a computer, access the internet. These are things that are not allowed. You can't download software without permission. You can't make illegal copies of software without the license, and so forth. So all of these are potential reasons for terminating employees, and of course, some of them may require you to skip all of the steps, such as verbal warnings, written warnings, and go right to immediate termination. Really depends on the severity of the situation. When you do have a violation of any company policy, just again, we have to make sure that employees understand what these policies are. When you have new employees and you're onboarding them, this is a great time, of course, to review key policies. I wouldn't stop there, though. I would have a review of key policies with employees annually, and I would document that. So it doesn't have to be very long. It can be like just a quick review of the employee handbook. It could be a quick review of some key policies, such as your attendance policy or harassment policy, or any of the policies that tend to be the reasons why most people are disciplined or terminated. Make sure that when you do have expectations and policies, that they are very clearly communicated. Make sure that people understand what it is that you're saying. I like the use of quizzes, and I know that it can seem cumbersome, but just a few questions, kind of like we're doing these polling questions, can really help people to retain the information that's given to them. So I like the idea of having like a review of what the meeting was about, or what a review of the content of the discussion that you had. Also, people need to understand that there are consequences of violations, so be clear about what those are. And again, document when there are violations and apply the appropriate consequences. So I think you want to be consistent. So if for the first time a person is absent, you might want to do verbal counseling. But if a person is a no-call, no-show, that seems to be a more serious violation. So that may require doing a written warning first. So you can jump around and go to whatever consequence you think is the best one for the situation, while also considering consistency throughout the organization. That's why oftentimes managers and supervisors are asked to first review all disciplinary actions with either their manager or the HR person ahead of time. And it's not because the manager isn't able to handle these situations on their own. It's just a good way to ensure that there's some consistency in the organization about what consequences are applied to different violations. And of course, we can terminate employees for breaking the law. Hopefully this never happens, but if it does, be sure to ask these questions. Did the illegal activity take place at work or outside of work? Was the employee convicted, and was the crime related to the job? Very important questions. We also have the dishonest employee. Unfortunately, this is obviously something that you would want to address, and sometimes it's necessary to terminate employees for this reason. The behavior must, of course, be work-related. You want to make sure that you do have solid evidence. I had a couple of times, unfortunately, in my career where there was a person in accounting, and in one case it was a person doing our payroll, who were being dishonest. And so we had to collect the evidence before we terminated them for that reason. You want to make sure you do have that solid evidence. And it does come in many forms, and I suggest have your employees sign a code of ethics. I think it really puts people on notice to understand what's expected of them, and also that the culture of your organization is not going to support dishonesty in any form. All right, we have another question.
Wow, that came up quickly. Okay, so the next question that is on your screen, and I think our audience is doing very well. Lying about required credentials or work experience on a job application would probably be considered adequate grounds for termination. Lying about required credentials or work experience on a job application would probably be considered adequate grounds for termination. And our audience is voting now. And Anne-Marie, I would have to say that it's an overwhelming 91% felt that true, and 9% felt false.
All right. Yes, it is true, and I'd say that the type of dishonesty is, lying on a job application is very serious. It has a direct impact on the employee's ability to perform the job generally, and that kind of behavior probably would be grounds for dismissal. And that's why I always suggest have your employees fill out an employment application. A resume outlining their experience is not the same type of legal document as the application. The application has that statement usually at the bottom that says everything that you've written in is true, and it requires the employee's signature. So that's why I think, and for a number of reasons, that the job application is so important. You can later, if you find out they have lied, use that particular document as your evidence. And of course, we can fire people for threats to workplace safety. This can include drug and alcohol policy violations, reckless behavior, certainly if there's threats and intimidation, and again, document, document, document.
And it looks like we have another polling question, Anne-Marie.
That's right.
And I will launch that for our audience. Employees who come to work under the influence of drugs or alcohol are protected under the ADA and cannot be terminated. True or false? Employees who come to work under the influence of drugs or alcohol are protected under the ADA and cannot be terminated. True or false? Okay, and our audience has determined that 90% feel that they cannot be terminated. False, 90%, and true, 10%.
All right, so I would say the answer to this is false. Employees who come to work under the influence of drugs or alcohol are a huge safety risk to themselves and others. So as far as the protection under the ADA, alcoholism and addiction can be protected, and should a person have notified you that they intend to take some time off for some rehabilitation, you certainly would not want to fire them in that case. Because they would be protected, and they've pretty much put you on notice that they are going, that they have a problem. They intend to address it, but that doesn't give them the right to come to work under the influence. That is definitely something that an organization needs to take seriously, and especially if they're in a position where safety is an issue. So you cannot fire a worker for seeking help for drug addiction or alcoholism, but you can fire someone if they come into work under the influence of drugs or alcohol. If they complain about safety issues, certainly you would not want to fire them. If they're just cooperating with OSHA inspectors, or of course if they're refusing to perform something that's dangerous or is a safety risk. And then we have layoffs, reductions in force, and when we have these particular events, we want to make sure that we are clear about the business reason. How many people are we going to lay off? What's the reason? How did we select this person or people to, why is it that they've been selected and not the others? So you want to make sure that you have clearly communicated and documented all of the business reasons for your decisions. You want to make sure that you give effective notice, and that can include complying with the WARN Act if applicable. And I'm just going to take you and show you this particular website, which is part of the California Employee Development Department. Here we go. I urge you to take a look at this particular website, and you can see in California we also have our own WARN law, and there's also a federal law. So this particular website is very helpful because it is a comparison between the federal provisions and the state provisions. It talks about who's covered, the reasons, the layoffs that require the notice, legal jurisdictions, and so forth. But the notice requirements have to be followed. And so this is extremely important, and a lot of organizations don't realize that this may apply to them. So if you are going to have a layoff, I urge you to take a look at whether or not you have to do any of the fulfill any of these requirements.
And Anne-Marie, for those on the call noticed from Oregon and Colorado, I am certain they probably have similar. The WARN Act is a federal standard, correct?
Yes, it is, absolutely. So that would apply to all of us, but then there may be some state provisions, and you'll want to make sure that you're exploring whether you have your own provisions in your state. And you have to comply with whatever provisions, of course, are the most employee-friendly, the ones that are most advantageous to the employee.
Thank you, Anne-Marie.
Yeah. Make sure that workers receive any pay and benefits to which they're entitled. Consider the timing, of course, when you're notifying people. You want to make sure that you're giving them enough notification, and also what's the impact. So sometimes you may tell employees, well, we're going to be laying off at the end of the month, and many employees might leave as soon as they find a job. And well, I can't blame them. I think most of us would do the same thing. But what would be the business impact if most of the employees were to leave before the end of the month? You want to consider that. You want to give them enough notice, but yet you still have a business to operate. So do you give them some kind of incentive to stay until the end of the month? Well, it's something to consider. Also, you need to address the impact on the remaining employees. This is extremely important. We know if we've ever been through any kind of layoff or reduction in force that it does have a very serious impact on morale, and employees are always going to wonder how this will affect them, and also they feel bad for their friends. They almost feel guilty that they're still there and their friends aren't. So these are all part of what make us who we are, and we need to put that stuff out in the open and give employees a chance to talk that through. So sometimes it's helpful to have meetings with employees, kind of talk through what their concerns are. So some things to consider before you terminate. Do you have an at-will relationship, or do you have an employment contract with that individual? How long have they worked for you? How long have they been in that particular role? And are they part of a protected class? So what is a protected class? Well, it depends on what state you're in. There are federal protections under the Civil Rights Act, and there's also state protections in many states. California certainly is one of them. So you can go to the Department of Fair Employment and Housing website in California to check out the protected classes there. Or if you're in another state, as Steve mentioned some of the participants are, then you want to check out and see whether or not you in your own state have a Fair Employment Protection Agency. And on their website, you would find all those protected classes. So those include age, gender, national origin, sexual orientation, pregnancy, things of that nature. So you want to try to understand, is this person in a protected class? Is there a co-employer relationship? Is this a person that is working through an agency? Do you have that obligation under the federal or state WARN Acts? And then some questions to ask yourself before termination. These are all really good things to just ask yourself. If you're saying that you're laying the person off, how soon do you expect you're going to replace that position? What kind of history of complaints has the employee had? If the employee has consistently complained, let's say about a safety issue, and you let them go, they may jump to the conclusion, hey, well, they let me go because I reported a safety issue that the company didn't want to fix. So that could look very bad for the employer. And if the employee had complained, how has the company responded to those complaints? Maybe there's a perception of a hostile work environment. And I always ask, is this going to come as a surprise to the employee that they're being terminated? If it is, and I would suggest to go back and look at it. And the reason I do that is because really we all deserve to know whether or not we're meeting expectations. And if all of a sudden I find out that I'm not doing something right, and I could have fixed it a long time ago, and you never told me, then I'm going to feel like this is a very unfair termination. And when I feel something is unfair, I'm much more likely to bring some kind of claim against the employer because I feel like I haven't been dealt with in a fair manner. And also, is there a paper trail? And is that paper trail going to make me look, as the employer, make me look good? Is it going to help in my defense, or is it going to be detrimental? All right, so the paper trail. A paper trail looks like this. We have a performance appraisal usually, right? That's part of the paper trail. You want to make sure that if you're terminating someone for performance, take a look at their file, and if it says that they exceed expectations, and you're letting them go because they don't meet expectations, that's very contrary. So you'll want to explore that a little bit before you terminate. What kind of written records do you have on file? Is there anything that, any emails, any things in the file that would support or not support your reason for termination? Are there any written warnings? And then once you feel that you have grounds for dismissal, I would suggest writing that down, not necessarily to share with the employee, but to share, I think writing things down is very, very helpful to document, okay, this is what happened, this is what I did in response, this is a written warning the person got, this is the next step I took, this is the training I gave them, and so forth. And, this is the final incident, and this is the grounds for dismissal. And then involving more than one person in the termination discussion, okay, well, this is what I want to do, and this is why I want to do it. And can you help me vet this? Can you help me look at this and see, are there any potential issues here? Is there any particular way in which I could approach this? Is there another option instead of termination? All of those things. So take a look at your paper trail. And fairness. Fairness is a huge deal. What the courts are going to look at is whether or not there's just cause or whether there's been due process. So these are the things that you're going to be questioned about. And so I find that this particular chart is extremely helpful. For just cause, was the employee warned? Did they understand what the consequences were? Is this a reasonable thing to require an employee to do? And did the manager really investigate? Did they understand fully what was happening before they jumped to the disciplinary action? And was it a fair and impartial investigation? Is there evidence? And have the rules and the consequences been applied even-handedly? And was the penalty or the discipline reasonable for that particular offense? And then we have the due process considerations too. What's the precedences that exist? Is there a process available by which employees can complain without retaliation? Was there any retaliation used? Did the employer make the decision based on facts? And were those actions and processes, would they be viewed as fair by someone from the outside? So these are really key components if you want to evaluate whether this is going to be a fair termination. Some things to consider and decide upon before terminating include, do we consult with that employment law attorney? Do we provide some severance? And if we do, should we give them a separation agreement? we have to give them final pay, but what has to be included? And also, is there a bonus? Is there one that is pending, and are they owed a bonus? And also, what about their insurance? What about their benefits? How long will they continue? And also, sometimes it makes sense, especially in a large reduction in force situation, whereby you want to consider offering some type of outplacement assistance. Some additional risk assessment before jumping to that termination final stage is, do we anticipate any workplace violence? What kind of security or IT issues might there be? How are we going to go about getting back company property? Have we confidentiality and proprietary agreements in place with employees? And will they continue to be valid after the termination? And what will the company's response be to inquiries about that employee after they're fired? And what is this going to do to the company's reputation? And just some final observations before we wrap it up today. Please think very carefully before deciding to terminate. Once you do decide, don't drag your feet. Not that you should do it too quickly either. You want to go through all the steps, but you don't want people to hang on too long. You don't want to keep on giving them second chances, third chances, fourth chances. You want to make sure, of course, that you're considering firing people with dignity and respect, which would mean in a private way. Have an HR specialist at the meeting. I would say if don't have an HR person available, have someone, other manager available during in the room at that during that discussion. If it's appropriate, HR can conduct an exit interview, and also make sure that after the termination that you communicate well with your internal and external constituents. So that would be your employees and customers or anyone else that this termination may affect. And with that, we wrap up this presentation, and we are happy to answer any questions that you might have. And Steve?
I'm sorry. We're launching one last quick poll, Anne-Marie, which is just asking our audience if they found value in today's webinar, and they'll just give us a moment for that. But we do have a number of questions from our audience, so I'll start with the first couple, if that's okay, Anne-Marie.
Perfect.
And I'll try to lump them together. And folks, by the way, if we did not get to your question within the next few minutes, you can certainly email us at moderator@aspenrmg.com. Anne-Marie, you spoke about job descriptions being filled in / at the HR office, as in at times employees do not remember what the job description details. The question is it illegal to work without a job description?
No, there's no legal requirement to have a job description. It makes sense to have one for a lot of reasons, but there's no legal requirement.
Okay. Is there a length of time that an employee can be suspended without pay if an investigation is needed?
Before suspending an employee without pay, I would carefully consider, I'm not in favor of doing that at all, actually. Yeah.
Yeah, we hear about the suspended without pay, you know, in perhaps television and such, but in the real world, Anne-Marie, does that happen? I mean, do you see that happening in most of your employee relations and termination, you know, as you're moving towards separation? Is that a step?
Yeah, you know, I see, again, and you know, it's difficult to say without examining a particular situation. So there's no general rule, there's no legal length of time, none of that. So that's the simple answer to the question.
Okay.
But what I want to pass on here is that it can be used as a disciplinary tool to say, okay, well, you know, this is your final warning, and I'm going to give you some days off without pay as a further disciplinary measure. It's, you know, obviously that's a very, you know, depending on the individual. Most of the time this is used on this type of discipline is used on entry-level workers. I've not really seen it used on professional workers at all. It's usually used on entry-level type workers, and those absences without pay have a significant impact on people. So I would be very careful about using it. I'd use it sparingly, and I wouldn't use it at all if in the event that you're doing an investigation of some kind, because you really want to assume that the person is, isn't guilty. Assume that they're not guilty until proven otherwise. So, while you're conducting an investigation, if you want somebody to not come to work, I would suggest you probably pay them while you do the investigation.
Great point.
Depending on the result of your investigation might be that you're going to terminate the employee, and then maybe you make the last day the day you put them out. But it's encouragement
to get your investigation done, pay the person is what you're suggesting, and get your investigation done, and then make a determination.
Yeah.
2 questions relating to quote under the well, actually there are 3 of them, but I'll read the ones. Maybe Anne-Marie, in a general, 30-second response, what proof is necessary to prove, if that's the correct term, that an employee is under the influence?
Well, I wouldn't do it as a solo. I would make sure that you had someone else that's also witnessing the behaviors. So they're the typical things that one would expect. There's the smell, if it's alcohol. There's the erratic behavior. There could be slurring. It could be any number of things. It could be actually seeing someone using drugs at the workplace. So you want to make sure that you have witnesses and that you can specifically describe the conduct.
And I would suspect, Anne-Marie, that if a company is going to that level of identifying someone under the influence, would there be some sort of policy or procedure for this? This wouldn't just be arbitrary, or is it just arbitrary?
Right, that's a good question. So, I usually would, get someone to. I would have a policy in place. I would also suggest that managers be trained on how to recognize this and how to deal with it, because you don't want to send people home if they're under the influence. They may get in an accident on the way. So you really do want to have policies and procedures and some training for your management team. And often if you have an employee assistance program in place in your organization, there's usually training available through that insurance for your management team.
Anne-Marie, there is a question about the hiring of laid-off employees. And this is relating to a company apparently that is hiring employees down the road. Do they have to hire people laid off before they would hire new candidates?
Well, that depends. It depends on what you've communicated to your employees, and maybe if you're, it could be a union situation, your employees belong to a labor union. So you want to be careful about what you communicate to your employees. Oftentimes, employees are specifically told that they would have to apply for any openings just like anyone else would, and they won't get, picked first. Steve, are you muted?
I'm sorry. We have 2 more questions for you. This is an audience that was really involved today.
That's great.
Yeah, when an employee leaves the firm voluntarily, is there a protocol or paperwork that's expected from the employer?
Voluntary terminations, I would always get a letter of resignation from the employee. It can be on the form of an email. And always make sure that your letters of resignation state the reason. I see that missing in most letters of resignation. So the resignation letter should include, their reason. Well, they have another job, or they're moving, or they've decided not to work anymore, or whatever. So I would get a letter of resignation, and there should be some policies and procedures set up in your organization to make sure the person gets their final pay, any brochures or notices that are required by the state, as well as to make sure that you're collecting any materials that the employee may have, and also reminding them of any confidentiality and proprietary agreements that they may have signed that remain valid as they leave the organization. So I would suggest to have a checklist of some sort that applies to your organization in whatever state you're in.
Great. And then we have one more question, but then a statement. It looks like someone responded to the question about suspending without pay, and they're simply supporting what you said, Anne-Marie, saying it was recommended from our attorney that people not be put off without pay, per se. So I think that goes to what you shared earlier about being very cautious in that area of suspension without pay during an investigation.
Yeah.
All right, we actually have another question added. What about exit interviews when an employee separates voluntarily? It sounds like the same sort of process that you suggested before.
Yeah, I really like I like that exit interview very much. I conduct those for my clients for voluntary separations, and it's very enlightening because employees will tend to be much more forthcoming about their experience. It can be very helpful for employers. If you're really open to change and you want to look for trends and ways in which to improve your. I ask questions about, well, what was it like when you first started here? Was it a good experience? Was there, how was your training? Is there anything that you would do differently? What do you think about the benefits, about working here? So it's great opportunity. Yes, I like exit interviews.
Last question appears to be something a little bit, different than what we discussed today, but it's about a person over 40 years old. Can that person be terminated in the same way? They've received several warnings, but is there anything different than a person that would be over 40 years old or 40 years or younger?
Well, they are in a protected class, so you want to make sure that your terminations aren't always, seemingly to be people that are older. If it looks like there's a trend there, then you might be more susceptible to that issue. But if you have, if there doesn't seem to be any kind of a trend and you're treating everyone the same, then you should be okay.
Okay. And Anne-Marie, gosh, a couple more questions came in. I know we'll wrap up here in just a minute. Okay. One is this relates back to this question of suspension. This relates all back to the pay during the suspension or not pay during the suspension. So I'm not going to ask that one. Let's just see here. I apologize, Anne-Marie. We had quite a few of them. There was a question about, do you have any recommendations, and I think you probably answered this before, about any examples of internal communication to employees after a reduction in force. Would it be more along the lines of the WARN Act and the requirements of that, or is there something other that you might recommend?
Yeah, the WARN Act is very specific about what needs to be communicated to employees that are being laid off. What my suggestion was for the people that are remaining is just a recommendation and a suggestion. There's absolutely no legal requirement. But I think that the failure to recognize that people are going to be uneasy can really be detrimental to morale. So allowing people the opportunity to voice their concerns and share their feelings, and just recognizing that there's going to be a bit of a bit of time before people feel secure again. But you don't want to make any false promises either to people who are remaining. You don't say things like, oh, this will be our last go-around of reductions. Well, you can't really predict the future, so just be careful about what you communicate. But I think it's a good idea.
And I think our last question relates to one of the, perhaps, I think this is what the question entails, and that is employees with negative attitudes. This wouldn't necessarily be after RIF, but those that you have on staff. Can employees be terminated for a negative attitude? Does it go back to your slide, Anne-Marie, where you're talking about the different aspects of social media, et cetera? But what about negative attitudes?
Yeah.
Can you work towards a separation because of that?
I think so. I think it's important to address negative attitudes. And I think that it being as specific as possible would be helpful. So let's say that someone is pushing back every time they're told to do something. I take that person aside and say, when I asked you to do this the other day and you did that, that's unacceptable. That I need you to be on board. I need you to have more of a can-do attitude. So I'd be very specific about how that negative attitude is manifesting itself and the impact that is having. And then give some suggestions for ways in which they can react differently, and then hold them accountable.
Thank you very much, Anne-Marie. And for those of you that maybe have another question or weren't able to get it in, or we weren't able to find it as we close out, you certainly can email your questions to moderator@aspenrmg.com. Please feel free to do that. And all the materials today will be posted on the site later on this afternoon. And so that site that we went to earlier, materials will be there, including the presentation itself. Thank you, Anne-Marie, and thank you to a great audience. Wonderful.
Thank you, everyone. Have a great day.
Thank you, Anne-Marie. Bye now.